Okay, we're going to pick up our lesson here with civil liberties, and we're going to look at the 4th, 5th, 6th, and 8th Amendments in this lecture. These are your rights in regards to searches and seizures, in regards to trials, punishments, and things of that nature. So we're going to look at these together. The 4th Amendment is a little wordy. It says the right of the people to be secured in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall issue but upon probable cause, supported by oath or affirmations, and particularly describing the place to be searched, and the person or things to be seized. I apologize for that. And so this is protecting you against unreasonable searches and seizures and ensuring that a warrant is issued for a search or a seizure, and that they describe in detail the place and the items that are to be searched. And so we're going to look at the interpretations of this, and there are a couple of cases that I want to look at that do deal with the interpretations of the 4th Amendment. The first is Mapp versus Ohio in 1961, and it's one of the most important principles that has grown out of the 4th Amendment. And in this case, we're going to see the exclusionary rule be adopted, which is the ability of courts to exclude evidence obtained during an illegal search, and these things cannot be brought up in trial. So if the law enforcement officials do not engage in a proper search and seizure to the letter of the law with a warrant, etc., then these things cannot be used against you in a court of law. They can be excluded from testimony. And then we have Maryland versus King in 2013 that said the states have the ability to swap DNA from arrested individuals as part of the booking process, because this is no different than collecting fingerprints. And so they can take your DNA by swabbing your DNA, probably your cheek, as part of the booking process, and it does not infringe upon this unreasonable search and seizure, because it's just the same as if they were going to take your fingerprints, which they do. And then in 2014, in a case known as Riley versus California, it was an interpretation of the law that said that law enforcement officials cannot search a cell phone following an arrest. Instead, they must have a warrant to access the data on the phone, because it's essentially a small computer and it holds a lot of information. And so they cannot search your cell phone without a warrant. If we look at the 5th Amendment, very long. No person shall be held to answer for a capital or otherwise infamous crime unless on a presentment or indictment of a grand jury, except in cases arising in land or naval forces or in the militia, when the actual service in time of war or public danger. Nor shall any person be subject for the same offense to be twice put in jeopardy of life and limb, nor shall be compelled in any criminal case to be a witness against himself, nor be deprived of life, liberty, and property without the due process of law, nor shall private property be taken for public use without just compensation. I kind of call this one the big kahuna. There's lots of things that you are protected from in the 5th Amendment. These are your court-related rights. First of all, it guarantees your right to a grand jury. And a grand jury is a jury that determines whether sufficient evidence is available to justify a trial. Now, to be clear, a grand jury does not rule any person's innocence or guilt. It simply rules that there is enough evidence to go to trial to declare your innocence or your guilt. And this is at the national court system only, so it deals with the federal court system, and it is not incorporated into the state courts. Some state courts actually operate without grand juries, and so only if you are being tried at a federal level can you or must you be indicted by a grand jury. And so if they decide there is enough evidence against you for you to stand trial, they issue an indictment. The next protection is that of double jeopardy, a protection of a person for being tried for the same crime twice. Now, let me be clear. You can be tried for murder twice if you murder two different people, right? So just because you survived a murder conviction for one person does not mean you cannot be convicted of a murder of another person. But you cannot be tried twice for murdering the same person. If you're found innocent, they cannot retry the case again and again until you're found guilty, right? And so it's not like, okay, we lost here, so let's do a redo, and let's do a redo, and let's do a redo. No. If you are tried and convicted on a case, they cannot try you for that same case later. You're protected by double jeopardy. Now, let me put in a little disclaimer here for you folks. I am not a lawyer. I am not an attorney. I have a master's in political science. This should not be substituted for any professional legal counsel, should you need that. Consult an attorney. I am simply stating what I know regarding political science matters. So don't utilize me as your legal counsel, because I am not a lawyer. You're also protected from self-incrimination, meaning that you do not have to testify against yourself in a trial, but also the Miranda rights are going to grow out of this Fifth Amendment protection. Your Miranda rights are created as a method to protect you when you are arrested. You have the right to remain silent, you have the right to an attorney, and you do not make remarks that can be used against you, right? And self-incriminate you, because that is protected in the Fifth Amendment. So our Miranda rights come out of this self-incrimination clause of the Fifth Amendment. And then you're protected from eminent domain, which prohibits the taking of property by the government without compensation. Now, the government can attempt to take your property if it is going to benefit the public, but they must justly compensate you as the property owner. They cannot just seize it and throw you out. They have to purchase it from you. And so that's kind of a big issue that's going on right now with the wall issue. If a wall were to be built along the southern border, many families that own property along the border will be subjected to eminent domain and could be tossed off their land. They will be compensated for it, but that is not the desire of some of these individuals. So it's a very sticky situation. And then your Sixth Amendment. In all criminal prosecutions, the accused shall enjoy the right to a speedy and public trial by an impartial jury of the state and district wherein the crime shall have been committed, which district shall have been previously ascertained by law, and to be informed of the nature and cause of the accusation, to be confronted with witnesses against him, to have compulsory process for obtaining witnesses in his favor, and to have the assistance of counsel for his defense. So these are your trial rights. You have the right to a trial by jury of your peers. You have the right to be informed of what you are being prosecuted for. You have the right to have your attorney cross-examine the witnesses who are testifying against you. You have the right to obtain witnesses to testify in your favor. And you have the right to a counsel, meaning a lawyer, in your defense. And so one of the cases that comes out of this, or helps to interpret this, is Gideon versus Wainwright, in 1963. It incorporated the right to having a lawyer represent a person in trial at the state court level. Previously, this had been applied only at the national court level, and an individual, Wainwright, who had been in and out of jail his entire life, had been convicted on, I believe, breaking and entering. He became kind of a courthouse lawyer, studied the law while he was a jailhouse lawyer who had studied law while in prison, and he actually represented himself and filed the brief and said that he was not given representation at the state court level, and so the court ruled in favor of Gideon and said that this is something protected in the Sixth Amendment, and so it was incorporated at the state level. Different states had different rules regarding representation, and only in federal court were you guaranteed a counsel, but this incorporated this idea at the state level. And then the Eighth Amendment deems excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishment inflicted. Now, almost all of the debate that centers around the Eighth Amendment centers around the last clause of the amendment, nor cruel and unusual punishment. And so this brings us around to the idea of the death penalty. The court has overturned many state laws on death penalty because they were applied unevenly and against minority groups more often than others. And so they haven't overturned them on the basis that they are cruel and unusual. They have overturned them on the basis that they weren't applied evenly and equitably and fair. And so these courts, these cases that, these states that had these overturned death penalty cases revamped death penalty laws, and the courts have reaffirmed states' abilities to utilize the death penalty. And so over a 40-year period between 1976 and 2016, 1,439 individuals had been executed by the death penalty. 538 of them were in Texas alone. And so as of 2016, 31 states had capital punishment statutes and 19 others barred the death penalty. And so there's a lot of debate surrounding whether or not the death penalty is considered cruel and unusual punishment. And it has largely been left up to the states to decide this, and the Supreme Court hasn't stepped in to make this decision one way or another. I dare say at some point they probably will. It'll probably be something that the Supreme Court has to step in and decide, and then at some point it will be incorporated one way or another on all states. But for now, it is a state decision, and 31 states actually utilize the death penalty, while 19 have outlawed it. And interestingly enough, the United States is the only industrialized Western nation that actually still utilizes the death penalty. So that's just a little bit of food for thought. So that's going to end this lecture on civil liberties. When we come back, we're going to be looking at civil rights. So stay tuned for that.